Before the registration, when we filed the registration, it was given a separate different registration method. It was 22.
That one wants the admission on it.
Right, but I need to add over it. No admission.
That order it is not there. Everything on the admission. That only.
Hey, ಕೊಡ್ತಾರ
Compliance
ಎಂಟರ್ ಆರ್ಡರ್ ಶೀಟ್ ಇರುತ್ತೆ
ಅದರಲ್ಲೇ ಕೊಡ್ತಾರೆ.
ಅದರಲ್ಲಿ ಇರುತ್ತೆ.
No, the entire order sheet of this. The previous one was also included, but in the case status, it is given separately on the e-courts website. There is one case status page for.
But it will get explained on here. They will get.
They will bring the order sheet also there on the website. They will check.
Huh? What is the urgency? What do you want? Admission? When is the auction going to be held? Day after. What 1306? No, is it listed today? Wait, yes. Give it to him. We will find out why it has. When parties are present.
My lord, list number 2,
It
serial number
don't have a mention slip, right? So we'll, yes, go ahead.
my lord.
Please wait, sir. What are you start? Start. Yes. Huh? Huh? It will be called. Wait. Ah, most. It is already listed. Not listed. Final hearing, please move an application for early hearing, then give a memo. We will fix a date. File an app. Yes.
My lord, sorry, my lord.
Don't out of turn. Don't. We don't
List
do
number
it.
2, my lord.
Where were you? I mean, what you are waiting for invitation? You are sending here, right? Absent-minded. Acceptance service of notice on respondent number 4. 4 is held to be sufficient. Mr. So, current counsel undertakes to file wakalat on behalf of so and so. Office is directed to reflect his name as counsel for respondent number. Appeal has been admitted. Let the appeal be listed if Mr. C. If it's not admitted, then list it for orders on admission in the next week. Then 13 years. You are required to be served by publication. Yes.
It's I appear for the fifth respondent.
Oh, Mr. Naik, is it covered?
No. Lords, your lords are being misled. It's not covered. It's covered against them by your lordship's latest order. It may be posted for hearing.
Filed counsel for the petitioner submits that the application seeking amendment of the writ petition shall be filed during the course of the day. Let the petition be listed for orders on admission in the next week. Next week, Mr. Naik.
Very well. Very well.
Huh? Oh, good. You take care of Mr. Lakshmi Narayan. Otherwise, he will not permit you to argue. Yes. Yes, Mr. What is Current counsel for the appellant seeks leave of this court to withdraw the memo filed seeking transposition. Accordingly, same is dismissed as not pressed. What is this, Mr. 6, 8? Allow. Now all these respondents have been served to allow all the applications and let the appeal be listed for orders on admission. Amended cost that will be filed within a week, list thereafter for orders on admission. You will have to say none correspondence those served. Yes. We call it there. What to do? Pay 1,000 for reasons assigned in IA 1 of 2023 duly supported by an affidavit. Order dated 21/10/2022 is recalled subject to payment of cost of ₹1,000 in the office of the High Court Legal Services Authority within a period of 1 week. Let the same be listed for orders on admission. Admitted or restored to file. It has been restored now. They can't take advantage of dismissal now. So file an application, whatever, what it is. Just don't say it. It's already been acted.
I appear for the appellant, Your Lordship.
Yes, non filing of objection.
We have filed the objection, my lord.
When?
And there has been a respondent number 7 has filed an application for production of documents, the copy of which has been served to me on Thursday, my lord. I seek for a week's time to file objection for the same.
What is filed?
Respondent number 7 has filed an interlocutory application for production of additional documents, Your Lordship. By respondent number 7, I have been served with the copy on Thursday, Your Lordship.
Counsel for the appellant prays for an a week time to enable her to file objections filed by the respondent number 7 seeking production of documents. This thereafter.
Obliged, Your Lordship.
Memo has been filed seeking leave of the court to withdraw the appeal. The aforesaid memo is taken on record. It is discussed as on same order in 7. On deposit. Let the amount of ₹10,000 as directed by a bench of this court be deposited within a period of 10 days, failing which appropriate order shall be passed. Say none for the act. 2 weeks peremptory. Or 2 weeks peremptory. Weeks peremptory. 2 weeks failing which appeal shall stand dismissed for respondent number 3. Office of we call it as assigned duly supported. Delay condonation allowed so and so restored to file subject to payment of cost of ₹1,000 before High Court Legal Services Committee within authority in the office of control. It is 1 week. File. Current counsel for the appellant submits that the copies of the news item showing the paper publication has already been filed in the submission. Office objection is ignored. Let the appeal be listed for orders on admission. Order, if any, shall continue. And say, move the leave taken on record this as before. Mediation report. It has been settled. Yes. memo has been filed seeking acceptance of the report of service of notice of respondent to paper publication for the reasons assigned. Same is accepted. What is it, Mr.? What is it? Appeal against what?
Friends appeal against dismissal of this petition.
Petition under
31A.
13(1). Appeal is admitted for hearing issue notice. But appeal is admitted for hearing. That's it. Record. Office is directed. Don't say issue notice. Step in serve. 2 weeks preemptive. Week preemptive. By 2 weeks. It is 27. This intra-court appeal has been filed against an order dated 10th of February 2022 passed by the single judge in exercise of powers under Article 227 of the Constitution of India. Line below. You know that law laid down. We have written. Appeal is not maintainable with the liberty to the appellant to take recourse to such remedy as may be available to him in law. None for the appellant. 7 days filing appeal condoned. IA allowed admit.
I beg to appear for respondent, my lord. This matter kindly may be connected along with MFA 6419/2021, my lord.
Delay condoned. Appeal is admitted for hearing. For analogous hearing along with MFA number
6419/2021.
Yes.
Please, my lord.
Why? There's no I. The direction. What direction you want? What direction? Any idea, madam? No, 9th of January 23, we granted you time. What are you doing right? Okay, last date only we granted you time. Let objections to IA1 of 2022 be filed within a period of 3 days. Within a period of during the course of this week, failing which appropriate orders on IA1 of 2022 shall be passed this on 23rd January. Kumar Bia. 21. 22. What is it? Early hearing. What?
In this matter, my lord. For the respondent in this matter, my lord.
We'll fix a date last week of January. Any date?
Please, my lord.
31st January. Taking into account the nature of controversy involved in this appeal, IA1 of 23 is allowed. List for final hearing on 31st of January 23. 23. To notice of IA1 of 2022. Office is directed to secure the record. 24. Objections? Why are you running? Did not go for a jog in the morning. Huh? Jogging here. Huh? During the course of the day. Learned counsel for respondent shall file objection. Course of the day. This on 18th January 20. 18th January. Yeah. Yes, issued notice of IA 1 of 23 record. For admission, huh? That's what he will not, that's why he will not appear. It is stated at the bar that appellant number 1 has expired. Let the application seeking substitution of LRs of deceased appellant number 1 be filed. What you putting? Huh? Money. What you want to delete his name? You have filed. You will file. Learned counsel for the appellant submits that the appellant number 1A has expired on 12th of January 23. He therefore praise fund is granted. How much time? 10 days time to enable him to move an application seeking substitution of LRs of disease. This you have been telling us for long, right? Settle. Oh. All right. All right. Learned counsel for the parties. Learned counsel mark their presence. Learned counsel for the party joins that the dispute involved between the parties has been amicably settled. They therefore pray for and are granted 2 weeks time to enable them to report settlement list on 25th January 26. It's stated that dispute between the appellant and respondents 1 and 2 has been amicably resolved, right? And 25th January you report. Good. We also feel happy when we are told that dispute has been settled. Admitted for hearing. Record. 29. Learned counsel for the appellant states that the amended cost title shall be filed during the course of the day and the amendment in the cost title will be carried out. When do you want? So it has to be argued on admission. When, what date? Day after? Next week? Just in the next week. What is it? All right. Then say IA 4 of 22 does not survive for consideration. Same is this code. Right? As for orders on admission. He wants to file an amended cost title. Next week. Huh? Yes. learned additional government advocate prays for session to enable him to file amended first title list in the next week. Admitted for hearing record. Admitted for hearing record. So it has to be, we'll admit it, this has to be heard, right? Yes, Mr. Lakshmi Narayan, some date you tell of your convenience, we'll fix it. We'll admit it formally and fix the date. Tell us what date. Will have to be heard. So please supply all those and tell us the date of your choice. So all right, that's fine. So why do you want after what to do what? We have asked you, please tell a date. Your convenience, we'll fix it for a hearing. Can be heard, and in addition, what he has said is that you are trying to or you are paying some additional revised amount to them. He says that payment of that amount be made subject to result of the writ appeal, though it doesn't require. No, he's saying government order, in view of government order, there you are trying to pay some revised amount to their account. We will say if any. If any. We will say if any. We will admit it, and we will see that if any revised amount is paid, it shall be subject to outcome of this appeal. It's not that you are paying. If any is paid, that's his submission. His submission. We will record his submission. If any it is being paid, it shall be. That only. Oh, yeah, of course, anything is subject. Oh, everything. Appeal is admitted for hearing. Learned senior counsel for the respondent submits. Learned senior counsel for the respondent submits that under the government order, the appellant is making payment of a revised amount to the GVPs, Gramin Vidyut Pratinidhis, full stop. Learned senior counsel for the appellant, however, prays for adjournment to enable him to seek instructions in this regard. Paragraph B, that as it may, comma, it is if any revised amount is paid by the appellant to the Gramin Vidyut Pratinidhis, the same shall be subject to result of this appeal. Government has issued an order dated 3rd of January 23, in pursuance of which a revised amount is being paid by the appellant in to the Gramin Vidyut Pratinidhis. Are subject to that. So what date?
After 2 weeks, there are some more matters.
You tell us. For us, every day is fine.
Speak of every
Lakshmi Narayan. Can be. All right. You tell us whatever. What sixth or seventh or what? It commences from 13th February. 13th February. List for final hearing on 13th of February 2020. Along with connected appeals. Please give a number, Mr. Interim orders granted on earlier occasion shall continue.
Dispatch.
33.3.
We already
3.3 issue notice to respond.
but an interim order not granted from the court, permitting us to submit only appeal memo. Identical papers are there. Pursuant to that.
No, that's why he says no, there is an interim order. What is the date?
3/8/2021.
The light of order dated 3/8/2021 issue notice to respondents. 33.3. 34. Notice to respondents, office of this regard is ignored. 34. 34. Which case? 36. Learned counsel for the applicant and for the reasons assigned in IA 1 of 2022, the same is allowed. At amended cost that will be filed within a week. This thereafter for it. Password. Admitted for the issue notice. No, not this record. 39. Admitted for hearing record. 39. Party. Admitted for hearing issue notice record. Same order up to 43. Yes. 44. So you call 41, 40. 41, 42. I admit this. 44. 44. Admitted for hearing. 45. Is it about? Appeal is admitted for hearing. Let a copy of the same apply to learned counsel for respondent during the course of the day. Heard on IA 1 of 23, learned counsel for respondent praise warrant is granted. 3 weeks time to enable him to file objection. Similarly, meanwhile, it is directed that operation effect of improved judgment and decree so far as it directs of marriage shall remain state. Office is directed to reflect. Name of Mr. Pallav R as counsel corresponding.
First over matter.
You are saying right this. Keep it aside. Either copy. Yes. And for the apple, even when matter is called in second round, it appears not interested. This
35, the Sanjay Deer, Sankarappa.
yes.
Person who has been apprehended, my lord, with the-
It has finding has been recorded that it's a case of no evidence. Right? What is the evidence? What is the evidence? Then, if somebody tells that this person has committed theft, that very person is not examined, what happens? Huh? Forget about it. Mr. 5 liters, you have spent more amount than 5 liters. Huh? Somewhere, you have to draw a line, right? Somewhere, Judicial Tribunal, single judge, then you will now challenge it before SLP. Say telling the corporation it's a fit case for filing SLP. 5 liters. What? This petition. This appeal has been filed against an order dated 30 May 2021, passed by Learned Single Judge, by which the petition preferred by the appellant has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that respondent was employed as a driver in Karnataka State Road Transport Corporation. In bracket herein after referred to as the corporation. Full stop. The corporation received a complaint that the respondent along with one Shivanand Gowda, store in charge, Kolar Depot, committed a theft of 5 liters of engine oil and sold the same for a sum of rupees 300. Thereupon, full stop. The aforesaid Sri Shivanand was caught red-handed on 13/2/2009. Full stop. At that time, aforesaid Shivanand Gowda did not disclose that he committed a theft in respect of 5 liters of engine oil along with in collusion with respondent and the respondent. Full stop. Aforesaid Sri Shivanand Gowda submitted his initial statement. Thereafter, he submitted an additional statement in which the name of respondent was also disclosed. Paragraph. Thereafter, a disciplinary proceeding was initiated against the appellant and against the respondent and opposite Shivanand of Shivanand, full stop, in the domestic inquiry. Full stop. Thereafter, an order of penalty was imposed on the respondent by an order dated 27/1/2011, by which his basic pay was reduced by one incremental stage without any cumulative effect for a period of 2 years. The respondent challenged the aforesaid order in a writ petition, full stop, learned single judge, by an order dated 31st May 2021. 31st May 2021, inter alia held that that there was no evidence from the court to the charge against the respondent. Accordingly, the order passed by the industrial tribunal was set aside. What have it? Second inquiry by an order dated so and so. Post right. Thereafter, you write. Thereafter, to I think for a period of 2 years. No? Thereafter, that sentence, the dispute was referred for adjudication. The industrial tribunal, by an order dated 8/6/2017, inter alia agreed that the domestic inquiry held against the respondent is not fair and proper, and an award was passed in favor of the respondent. And an award was passed in favor of the respondent inter alia on the ground that Shivanna Gowda, who was involved in the alleged theft, was not examined in the inquiry held against the respondent, right? And thereafter, that is whatever you have written. The judge held no evidence, and what has been last?
There was no evidence
Right.
against
the aforesaid factual background, this appeal has been filed. Learned counsel for the appellant submitted that the learned single judge and that the industrial tribunal as well as learned single judge grossly erred in holding that merely because the Shivanna Gowda was examined in the inquiry conducted against the respondent, the charges leveled against the respondent were not proved. Paragraph. We have considered the submission made by learned counsel for the parties and have perused the record. The district tribunal as well as on the perusal of record, it is evident that one Shri Shivanna Gowda was caught red-handed on 23/2/2009. Committing a theft of the engine oil, did not disclose the name of the appellant initially. However, he submitted an additional statement subsequently in which it was stated that respondent is also involved in the commission of theft of the engine oil. Full stop. The opposite Shivanna Gowda ought to have been examined in the departmental inquiry, was a material witness and ought to have been examined in the departmental inquiry. So the appellant, full stop. The appellant, the corporation, neither examined him nor published any plausible reason for non-examination of the opposite material witness. Full stop. The industrial tribunal as well as learned single judge, on the basis of meticulous appreciation of evidence on record, have held that there is no material against the respondent to prove the charge against him. Full stop. The order passed by the aforesaid finding of fact does not call for any interference in this intra-court appeal. Paragraph. For the aforementioned reasons, we do not find any merit in this appeal. The same fails and is hereby. Yes. Happens to 2 lakhs. Learned counsel for the appellant submits that he has deposited the amount of rupees 2 lakhs before the executing court. However, the praise warrant is granted a week's time to enable him the aforesaid account.
Matters. Number. Total.
Number 2.
To the local authority. So we are not going to, it's not a standard one. We'll have to, the report will be
How much time?
2 weeks.
Learned counsel for BPMP, Mr. V. Srinidhi. Learned counsel for BPMP praise warrant is granted 2 weeks further time to enable him to file the status.
Number 2. Rahmatullah Kapoor. Abhi Ashok.
Two point one. Offices, 2.1, you write offices direct, when it has been disposed of. All right. Learned counsel for the applicant submits. 0.1, right? Learned counsel for the applicant submits that that this writ appeal has already been disposed of by an order dated 14/6/2022 in view of the submission. Let the same be delinked and be assigned to record. Yes.
You will do a resurvey of the
Counsel for relax. Did not jog in the morning. That's right. Especially the learned counsel for BBMP submits that that BBMP shall carry out a fresh resurvey in the presence of the appellant and shall submit a survey report. The praise form is granted 2 weeks time to do the new.
Government advocate, L. Anusha.
Is non-amendment of already cost title, let cost title be amended within a week. List thereof. Please there. Let them, it's for non-amendment, let them do it. Amend it will be. What is the prayer?
case officer positioning as No, sir, I said that I don't want to continue as. I may be given appropriate elsewhere. Because of.
No, so, but it has, order has to be passed by the government. Yes,
I said. They are not able to start.
in the other side, council for petition is not there, either we pass it over them. If one time, we pass it over, let's see. So mark we will record your statement. You are appearing for item 4. Learned counsel for, just a minute. Learned counsel for the pleading applicant submits that he has filed an affidavit stating that he does not want to continue as Special Deputy Commissioner 1, Bangalore Urban District. And however, no orders. However, and has filed an application. And has filed an application before. Filed an application before the state government. Paragraph. In view of aforesaid learned additional government advocate, grace warrant is granted a week's time to enable her to seek instruction and to make a statement. It's on 23rd January.
Okay.
What office? His objections, etc. What is?
Report,
Huh.
allegations against respondent number 5 has been proved, but still today no action has been taken against him. And he is still continuing as a commissioner of CMC. Report by kind district. CMC.
You tell us next week what action. We'll fix the date 24th. Learned additional government advocate submits that the audit report 7/10/2022 has been forwarded by Commissioner by Director Municipal Administration to the state government, to the secretary to the government, and suitable action on the aforesaid audit report shall be taken. She, however, prays for a short accommodation to enable her to make a statement in this regard. List on 24th January 2023. 25th January. What? Recall of the order. What is recall of the order dated 5/9? What have you done? Available warrant. So did he appear? Then what is the recall? What is it? I mean, has it been complied with? What is it for the petitioner? Where? What is the direction? What is, Mr. What is the direction?
Direction is to allow infinity degree of the activity of the land within the area of the. Yeah, what are the both sides? Now, madam, they have filed nothing. After the both sides, they have filed nothing. After both sides, one side, he had. What's there?
You are. And for the petitioner, Mr. B.S. Sachin, learned counsel for respondents who are in taking appearance of learned counsel for the petitioner, hearing is deferred this next week.
Gurudev Gachinmat.
You are also praying for time. Learn it. Already have. Learn it. Learn it. Counsel for respondent submits that she shall file the compliance report on or before next date of hearing. List in the next week. No. Then in the beginning, you write heard on IA 1 of 22, taking into account same is allowed. Let amend. You do it. First, that will be amended during the course of the day. And then her state. What office? Eh?
Only complaint with the court to the order.
What is the office objection on your counter affidavit? You haven't done it, right?
They seem to be agreed by. An order with this. Cannot comply with order.
Comply with the, we'll list it next week. You comply with the office objection. Learn it. Counsel for, yes, next week. What date you want? Learn it. Learn it. Counsel for respondent. That is to comply with office objection within 3 days. List on 25th January. I also say, right, say.
Number 10.
Babu. Babu.
What brings you in contempt petition? Yes. Nobody is appearing. Respondent, what? Notice has been issued, right? Who appears? Speak. Mr. D.R. Ravish. Correct year council, none for respond number 1. It's gone. For 23rd, 24th, what? 23rd January 26th. Yes. It is. Let the petition be listed in the course of next week. Next week. Interim order. No, we have not said anything. Next week, let IA 4 of 2022 be listed. You say let IA 4 of 22 be listed for consideration in the next week. The council correspondent grace fund is granted. How much time? 2 weeks. 2 weeks time to enable him to file. Statement of objection. Statement of You need some time. Oh, narrate counsel for the petitioner praise for plot accommodation list after 1 week. Oh, that's all. Yes, learned counsel for the petitioner praise fund is granted a week's time to enable them to file rejoin the list thereafter. Learned counsel correspondent, you have to file what of statement of objection.
Yes.
Learned counsel correspondent to be Srinidhi learned counsel correspondent praise fund is granted 3 weeks time to enable him to file statement of objection.
I appear for the petitioner, Your Lordship.
6 time is granted to comply with office objection. Yes. Affidavit you have filed. The counsel correspondent undertakes to apply a copy of the compliance affidavit filed on behalf of the respondent to learned counsel for the petitioner during the course of the day.
I was granted. Really to pass an order within the time period, petition would be entered cost of 5,000 per week. The late period in the order is passed.
Go through what he has said, thereafter we'll decide. Yes. Huh? It has been complied with. Learned counsel for the parties jointly submit that the order dated what? Then what settle? You can't settle like this. This contempt. We'll have to make a statement. Learned counsel for the petitioner. Learned counsel for the petitioner submits that the directions contained in the order dated 19th. Huh? 9. Direction. What learned counsel for the petitioners? What is your submission? It cannot be amicably settled. Violation of a court is if the order has been willfully disobeyed, that has to be. You cannot by compromising. I mean, take away the jurisdiction of this court to deal with contempt. You file contempt and then accept 50,000 rupees from the respondent, and they say, "No, I have complied. The matter is compromised." We don't know. We'll have to withdraw, or you say that it has been complied with. Choice is yours. Learned counsel for the petitioner submits that he does not want to prosecute this contempt petition. Attention of this court has been invited to the memo filed on behalf of the petitioner. The aforesaid memo is taken on record. The petition is we should be learned counsel for respondent praise fund granted weeks further time to enable him to fight off. Appliance report, who appears? You. How much time? Granted by way of Mr. V. Srinidhi, Learned Counsel. 30th January. 30th January. 0. Yes, madam. Had to be passed on IA 1 of 2022. The contempt petition has been filed in respect of an order passed in petition. Accordingly, IA 2 of 22 is disposed of. What about office objection, madam? After hearing learned counsel for the petitioner, office objection is the Learned counsel for respondent, Mr. Mead, learned counsel for respondent, place fund is granted 2 weeks time to enable him to file out.
Government advocate.
Learned counsel for the appellant, place for adjournment. Enable him to seek instructions list after 1 week. Same order. Counsel for the petitioner has produced the copy of annexure F. The office objection is therefore ignored. Let the petition be listed for orders on admission. Next week, list, we'll say next week. List for orders on admission in the next week. You can seek adjournment, right?
25. Here. It is right. I need to work on it. The order counting. Anyone?
No, there is a judgment on this, right? Has been decided against an order passed in review. It appealed. Hey, why don't you amend or examine the legal position if you have not? In view of the office objection raised by raised with regard to maintainability of the writ appeal, learned counsel for the appellant prays for adjournment to examine the aforesaid aspect and to address this court on the issue of maintainability of the appeal list in the next week. It's on 18th. We'll have to just amend it. Not for the petitioner awaiting appearance, hearing deferred.
Correct. 14%, Sri Ramesh Naik here, government advocate.
The petitioner. Then an additional government advocate prays for a court accommodation to enable her to seek instructions and to make a statement with regard to further progress in the matter. When you next week? Yes. Why 3 weeks? You have to just 31st January. 31st January. List on 31st January.
28. Okay.
For the petition. But whatever day after or if it's
Not to use it in the market.
for the petition. Ken Panindra Learned Senior Counsel for the pleading applicant. Awaiting appearance of Learned Counsel for the petitioner, hearing is deferred. Respond. This week you want 19th January 2023.
29. Srinivas Gowda ke. Shivkumar. How many rupees?
Let what last order sheet, Mr. C. Let objections, if any, on behalf of respondent and 3 be filed. Oh, it says none for the parties, then none for the petitioner, so and so. You are appearing for respondent number 2. None for respondents 1 and 3. Awaiting appearance of learned counsel for the party of petitioner as well as respondents 1 and 3. Hearing is deferred. List next week.
30. Government advocate.
And additional government advocate praise fund is granted a week's time to enable him to comply with office objection.
My lord, I appear for the appellant in this matter. And my lord, there are total 4 appeals have been filed arising from same common order. So today 2 have been listed. That is at serial number 31 and 32.
31 and 32 list for analogous hearing along with WA number. Let Ms. Rolla. Whenever I will. Tell us what. On. Thirtieth. Yes, madam. 30th January. No. 30th January.
Sir, 33. Punyar.
Yes. In the event petitioners have disbursed, they shall be inducted. So you are the shopkeepers. Then you have inducted them into shops. Mark her presence. Yes. Right. Between the light of order dated 1/12/2022, learned additional comment advocate praise fund is granted a week's further time, enabling to seek instructions and to file a report if so advised.
Since now, like for 8 weeks, 7 months.
He's praying for you. Have heard him weeks time. Interim order. I'll continue. Date. 1st January.
Trying to change the nature of the property by putting up small structures.
Don't change. Don't alter. Right, there's no point. Issue notice is on behalf of respondents is accepted by Mr. So and so. Heard on IA number 3 of 24 and 4 of 24. In the meanwhile, party shall not alter the nature of the land in question till next date of hearing. Fine, alter the nature. Don't do it. Nobody will advise you to do it, right? What happened? The appeal is allowed. Huh?
I appear for the respondent, Your Lordship. I pray for a week's time in this as I am not keeping well, Your Lordship.
Yes, madam, 30th January.
Yes, Your Lordship.
A list on 30th January 20.
Much obliged.
Yes.
Section 440. The other thing is that the regular actually interact again. Operating. Whereas the said order was budget fund of salaries and other things. So I get that status quo should be maintained in all respects.
One 306 of list for analogous hearing along with WA number 1306/2022. When do you want this revision? In the next week? Huh? On 18th of January 23, interim order shall continue. Court what? Oh. All right, you then move a memo, right? Why we should we give? Say next week. The order shall continue. Write a memo seeking leave of this court to withdraw the petition. That is same has been rendered. Is accordingly.
Yes, my lord, I pray for 1 week time, my lord. 39, next week.
Be able to prepare the case and argue the same list of one.
Much obliged.
And for the additional learned additional comment of it correspond number 2. Awaiting appearance. Hearing is deferred list after 1.
41, digital beer, government educate.
Taking care of home buyers. What is the effect? I mean, what is the adverse impact of this deletion? What is
There will be no safety norms to be followed. And it will be a violation against the
yes, madam? What do you say? You represent. Is there any standing counsel? Supply a copy. Let a copy of this petition along with the registers be supplied to Mr. S. Sriranga, learned senior counsel. Acha. Oh, yes, all right. Mr. Sumana Naganam, who ordinarily represents respondent number 3, office is directed to reflect her name as counsel for respondent number 3, list in the next week.
Number 42.
My lords, I appear for I'm holding for Mr. Ladda on behalf of respondent number 3 and 4. My lords, I pray for 2 weeks time. Mr. Ladda is not feeling well.
Feeling well?
Yes, my lords, he's on bed rest since yesterday. I sincerely pray for 2 weeks time.
Who is not well?
Mr. Ladda, my lords, advocate on record for respondent number 3.
SS Ladda.
SS Ladda.
This is here.
whom he is appearing.
We also don't know somebody is appearing saying some counsel is not well. Who is Mr. Ladda?
My lords, he is advocate on record for respondent numbers 3 and 4 is the matter. Mr. Sagar Somnath Ladda.
Yeah, this is the public interest land acquired for the establishment of bus stop. Now it is there. Petrol bunk is
There is an interim order.
But
We'll fix it. I mean.
After service of summons, in fact, this honorable court expressed that let the service be over, then we will consider. Now the service is over.
We'll let the petition be listed for consideration. Therefore, it will leave
No, I have not for it.
on 23rd January. He's praying for time. No, now he will get well. The moment he will realize that he will be all right.
No, my lords, that's not the case. I sincerely apologize for the inconvenience and
No interim order.
That's
Now
why we have
construction of- Let the construction be stopped till then.
So we don't want to say, you understand any construction made is subject to result of the petition, but we don't want to pass an order. He's saying some council is not well. We don't know who is he and which. He practices in Bangalore.
my lords, he is a standing counsel for NHAI all over, before Bangalore High Court and before Bombay High Court as well. He resides in Bombay. He resides in Aurangabad. Practices before the
That's
bench.
why.
He appears on video conference. He could have appeared had he been well. There's a genuine inconvenience here, my lords. There's genuine inability on his part, which is why I'm
23rd. 23rd.
Thing of construction, I am thinking. They are before the court.
23rd.
Yeah, sir. Yes, sir. We are sending it to mail as well as. Yes, sir.
23rd.
grateful, my lords.
They are not seeking any relief against you.
My lords, for the instructions I have submitted, my lords.
43.
I'm grateful, my lords.
Counsel for the petitioner. Raise fund is granted 3 weeks time to enable him to file a rejoinder.
44. Government advocate.
Which case? 44. 43, what happened? Wait for time. Oh. Yes. Yes, madam. Some are pending. Hold on. List along with. What? All right. Issue notice. Hold on. IA 1 of 22, 2 of 23. 1 of 23 and 2 of 20. Issue notice. Same order in 45. For one.
Passed over, man. Parties.
The appeal arises. So this appeal has filed against the judgment dated 16th of February 2021 passed by the family court, by which petition filed by the appellant. This of the True Marriage Act has been dismissed. In the beginning, you say parties about this appeal has been filed. Learned counsel for the parties jointly submit. What agreement? Submit that the dispute between the parties have been amicably settled. The conditions of the settlement are as under. So, copies are right between the parties. The marriage between the parties is dissolved by a decree of divorce. The appellant has handed over a sum of rupees 3,50,000 to respondent to respondent, then marriage is resolved, handed over DT so and so, line below. The appeal is disposed of in terms of compromise arrived at between the parties. Get their signatures.
I appeal for the respondent.
Yes. What is appearing for the appellant? What to do?
He has not been appearing at all. Even last occasion, Milord, day before yesterday, it was listed. In this racing, before the learned single judge, the party appeared in person. Thereafter, Milord, in the appeal, he has engaged.
Let's see, since when he is not appearing.
Friday it was study. That day was not there.
None had appeared on behalf of the appellant on
13th
30th of January 23 also. None had appeared on behalf of the appellant even today. This is Ramdas.
Yes.
Pradeep Saukar, Learned Counsel for respondent. Appears line below, it appears that the appellant is not interested in prosecuting the appeal. The same is accordingly dismissed.
Please.
Number 47, the Keshav Reddy MV, the Karuna yes, Kiran J.
Same. Same acquisition. Same judgment, right? We passed an article. Why? There is no reason not to be released. Right? His this thing. So you remember that staff had taken that girl.
Exactly.
Yes. Check means he will get it. What date of order? So difficult. Find out.
Thursday, number 818.
818 of which year? Must be 14, right? If it's 14. See, madam, 818 of 14. Got it? 818 WA. And I know that. Got it? Your printout, madam.
On your 818 of 2014, interpretation number 958 of 2014, and application number 978.
818, right?
818 of 2014.
Oh, madam, get it? You have got it. How, where from? You are not. Not 12th. That's why. 11 January, not 12 January. That's why you are unable to find. Not released and all. Huh? No, I'm surprised why it is not. We have signed it. Hardly any files which we don't sign. That's why. The order was passed in your presence.
Now,
Huh? No, madam, not getting it. 13 January. 818, get the copy, that's all. Whatever date it is, 818 of. Nataraj, WA 818 of 2014, if you type, you don't get it.
Yes, ma'am.
So why print out? Huh? 818 of 14.
for your following the court judgment.
Yes. We remember. He's telling the number, no, 818 of 2014. Why are you not getting?
No, he has gone, ma'am. Pune has gone. Sir,
Right?
he has gone to bring that out.
It has gone. But why she is not getting it? 818.
Sir.
818. Huh? She got it. That's what we also felt that she should get it. Why not get it? 818 of 14. Slow.
It's certified.
Oh, wait. Yes. That means he's right that it has not been released. Why it has not been released when it has been signed? But he's getting the file, right, Mr. Nataraj? 818 of 2014. Scanned. Then after scanning, it has to be released also. We'll do it. Oh, relax, Mr. Ravi Shankar. Relax. Nothing. Which was your item 47? Oh, so now that's all over now. You know, right? 818 of 2014, we have followed this judgment. Just other day we dismissed following justice this order. We cannot, and no, the matter is already in SLP, special leave petition. So Mr. This thing, who was there? Mr. Suman. We told him that. And SLP has already been filed. You can understand, right? We have. Which order? You see para 13, 5 issues framed. In his case, this part by principles of res judicata did not apply. Despite that, we have said that remaining 4 points, it's all covered. See, all right, yes, I will see. Para 13, Mr. Ravi Shankar, please. Yes, please see. So, probably the good news for you is that SLP has been filed, and we don't know. Probably he said notice has been. You see just now what is there. We will wait. No hurry. No hurry. Just go through it. It's all it's covered, right? We can't take a different view.
I actually understand. Just go to the convention slides that
This is only 3 pages. You just go to how does it? Please sit down, relax. Sit down and relax. We will go through it. Go through it at your leisure. No. Para 13 onwards. Then this all part by res judicata. The previously writ petition filed, etc. PCC case is a judgment in brief. Question: delay and approach latches. Delay and latches. Third party interests have been created. Extraordinary discretionary relief under Article 226. No. Obviously, there will be differences. Names will be different. Area of land will be different. Will be different. But WA 818, we have followed this. We can't take. Please appreciate our predicament. Now go through it. You say no. We will say that your contention is that it does not apply. We will record it applies. What Monday? Tomorrow? Okay. All right. But please argue tomorrow. And what we expect, you should tell your contention. We may record whatever you have to argue, but you must fairly, you must tell us that this is so. This is the order we have got. So we will say that you say that it is not covered, all different and all that. We can do today also. No, we will record that it does not apply. Yes, you keep it, Mr. Tomorrow. This case be called.
Government advocate.
Give it. So, name is required. Yes. Use for it then. So, just a minute. 42 cents.
In survey number 256/17. Village Mangalore Taluk was granted to respondent number 5 hearing. He served unrepresented before this honorable court. Currently, this appeal is unrepresented. Granted to him on 21/8/1935. Alienation clause 20 years. The appellate hearing purchased 15 cents out of 42 cents on 8/1/19.
Just a minute. On alienation cost
20 years.
20 years. Then
Appellant hearing purchased 15 cents on 8/1/1973.
8/1.
1873.
You
the Assistant Commissioner on an application filed. Initiated proceedings under Section 5 of the PPCL Act in the year 1983. And on the ground that the sale was.
When was the this proceeding initiated?
Page number 51 of the 15 minutes. 1983-84 is the case number. The application for resumption was allowed.
When was it allowed?
It was allowed on 10/8/1985. Section F of the report.
Then appeal.
Same was dismissed by the appeal was filed by the appellant on 14/11/1995. If the same was dismissed.
Why was it allowed?
The assistant commissioner allowed it on the ground that it is in contravention of section 4(1) of the act. Because
But this was before coming into force of the act, right?
ground that it is sold in favor of a person who does not belong to the SC/ST.
No, what happens to the sale taken place during before coming into force of the act?
That sale was meant to be void.
No. What is the effect we are asking, madam? This act came into force in the year 1978, so it reopens the past transactions also.
It's earlier.
Therefore, it won't be affected, right?
Appellant has to succeed due to this.
Appellant
has to succeed due to this.
The act won't apply because the sale was prior to this thing. Even otherwise, no infirmity because beyond alienation is beyond 20 years.
Appellant has
Right.
to succeed in stating the facts. Also confirms the order of the assistant commissioner.
Please ask, madam, if there is any difficulty, please ask. Please feel free to ask. I won't remember later, right? This intra-court appeal, you say none for the appellant, right? And her name, learned additional government advocate for respondent number 124. Say none for respondent number 5. Then this intra-court appeal has been filed against an order dated 3rd of July 2014, passed by the learned single judge, by which writ petition preferred by the appellant has been dismissed. Full stop. Paragraph. Facts giving rise to filing of this appeal briefly stated are that respondent number 5 was allotted land measuring 42 cents of survey number 256/17, situate at village Suratkal. Full stop. The order of grant contained a condition for non-alienation of the land for a period of 20 years. Full stop. Much after the expiry of the period, much after the expiry of the condition relating to non-alienation, the respondent number 5 sold 15 cents of land out of aforesaid 42 cents by to the appellant on 8/1/1973. Right? 8/1/1973, paragraph. Thereafter, PTCL Act. You will write the whole thing. PTCL Act. No, that's correct. You will write. You know. PTCL. And thereafter, so and so Act was enacted in the year 1978. To stop after commencement of the act. No, but this applies to even this section 4 even before this thing also.
as on that date.
Sure. Will not apply. That's what we want to know. It will not apply to sale prior to this thing.
Prior to the commitment of the act, even though there was a nomination for
Section 4.
granted in the favor of the press law. On that day, the law says that it should not be alienated forever.
Either or before or after commencement of the act. In contravention of the, all right, in all, yes. What have
Thereafter, the PTCL Act was inactive in the
the
year
so and so act was enacted in the year 1978. Section 4 of the act contains a prohibition of transfer of granted lands. Section 4 within bracket 1 provides that any transfer of granted land made either before or after the commencement of the act in contravention of the terms of the grant of such land shall be null and void. Full stop. Paragraph. The respondent number 5, however, filed an application sometime in the year 1983 seeking resumption of the land. The assistant commissioner, by an order dated 10/8/1985, 10/5/1985, 10/5/1985, allowed the application and directed resumption of land in favor of respondent number 5. Full stop. The appellant challenged the aforesaid order in an appeal, which was dismissed by the deputy commissioner by an order dated 14/11/1995. In the aforesaid factual background, this appeal has been filed. Paragraph. We have none has now say a paragraph. None has appeared on behalf of the parties. We have heard learned additional government advocate and have perused the record. Full stop. Section 4 within bracket 1 of the act, as stated supra. You should say that act herein after referred to as the act. Section 4 within bracket 1 of the act provides that that notwithstanding anything contained in any law, agreement, contract or instrument, any transfer of the land made either before or after the commencement of the act in contravention of the terms of grant shall be null and void. Full stop. In the instant case, the grant of the land was made on 21/8/1935. Full stop. After the expiry of the period prescribed in the in non-alienation clause, that is after a period of 20 years, respondent number 5 alienated a part of the land on 8/1/73 in favor of the appellant. 8/1 part of the land, that is 15 cents. 15 cents in favor of the appellant on 8/1/73. Full stop. Thus, the land was transferred in land was not transferred in favor of the appellant in violation of the terms and conditions of the grant. Full stop. Besides that, there was a delay in filing an application seeking resumption of the land, which is not permissible in law. See so and so. Please ask my staff. We will give you the case law. Tell Rupa madam to give her only case law, which we often use. If you have this on. So and so. Paragraph. However, the aforesaid aspect of the see so and so. Bracket you write there only. Yeah? Yes, paragraph. That's it. Then thus, however, the aforesaid aspect of the matter has neither been appreciated by the assistant commissioner nor by the deputy commissioner. Full stop. The order suffers from continuation. The order suffers from an error apparent on the face of the record as well as the vice of non-application of mind. Orders, not orders suffer from. So and so the impugned orders therefore cannot be sustained in the eye of law. The order stated so and so passed by the assistant commissioner and the deputy commissioner respectively are hereby quashed. In the result, line below, in the result, petition is in the result, appeal is allowed. Yes.
Number 49, Murgesh Therapy, G.B. Manjunath. Challenges we have. Thereafter, we got the land was unified from the acquisition. Now, thereafter, we make an application. Exactly.
1 minute, one. Then that is only see three judgments appear, delay and lag. That's all. When was the award passed?
One for 2006.
Yes.
And there was an order of status quo and escape.
What is the date of that order? Could have just given a synopsis and saved time, right? This all we are noting it down. What status quo, when it was granted?
12/11. This was on
30th August. 3rd of.
incentive. To permit you to read the rules for incentive, right?
When was the application made?
April 2009.
8/12/2009. Ah.
An application for incentive right. Incentive right for authority.
Give the book to him.
May Mr. Offended to be allot right incentive to an owner of the land. In response to the notice given under section 9 of the Land Acquisition Act 1984, he voluntarily hand over the voluntary hand over to the district commission possession of the land, which is being acquired from the under the said act on behalf of the authority, free from any objection whatsoever and from any unauthorized and
When was the final notice given under section 9?
23/9/2003.
When was the stay granted?
It was granted on 12/11/2003. After the
You can type, madam, here. Order which has been dictated.
after service 9 and 10. He did not voluntarily hand over the possession of the property. And it was not the incentive scheme where they expeditious completion of the activity. But I offer this getting to the award which I have.
Yes. Yes. Oh, did you hand over the possession voluntarily after notice?
So, what is it?
That's seven, we thought, next page. Though there is an area of doubt as to whether in fact the petitioner indeed had handed over the possession of land in the year 2004.
So para 7 is in the above facts and circumstances.
The above facts and circumstances is not delayed in the extent of creative location of the plan. Without any other petition, but it is also noted that the petitioner has charged the case to be ultimately paid. The question is whether they is by filing a report challenging the landholder is to be delayed the stop and incentive scheme could apply to the future.
So thereafter,
There are several
internal page 10 of the order you go there is.
As to whether in fact the petitioner indeed had handed over the land in 2004, nor could it be said with considering that the function of the basis of the project is to produce the BDA, that teaching is borrowed, the BDA has produced regular terms as a measure. As in commonly known, there was cases of some unknown which is a printed format. The land builder specifically explained by the document establishing the dating order of person. Such documents are being routinely negated with this court for renewable location. This is more. The such document does not give up the confidence of the court and cannot be said that it is made the test of law. Is establishing that the physical position of the land was taken only in the term. The fact remains that the system was taken. There is also no statement or material evidence to show that the implementation of the scheme was considerably delayed or otherwise prevented in the use of any interim order or delay in handing over the position or taking over the position and when it is not further instituted that the land is required in delay, it would stand to reason that the petitioner must be given the benefit of the incentive scheme is contemplated for an extent of land between more than 3 acres. The third period of the land owner will be entitled three times, that is 60-40, 30-40, 20-30, totally 4,000 according to the petition entitled to the same. Denial by the PDA on the ground that the petition challenge the circumstances for the rule not be a valid ground to be the same. There are so many
No. We very simple, Mr. There's nothing. Just a minute. Very simple. Whether in response to the notice issued to you under section 9, did you hand over the possession? No. There's no point. There was an order of status quo. How can you give possession? No. Mr.
After obtaining status order,
20th.
after obtaining status,
You handed over possession.
the BDA has initiated the promise to give 30 to release the 30 of the land because I have obtained conversion in the year 19 itself, much prior to notification. Much prior to the notification, I have obtained conversion and I have sold 30 of the land to various persons. That's why I requested to not give 30 plus to acquire 3 acres, 3 acres of 30 in the out of 4 acres, 30. Out of 4 acres, 3 I have sold.
So therefore, your case is that you have given possession in the year 2007. 7. This is the finding, Mr. Arey, Mr. This is an order.
So, for itself, the order.
Where is the finding 2004 you have given possession? There is no finding. Mr. Admittedly, in after issuance of notice under section.
On the basis of a measure which is produced by the, there is no signature of mine in that. I am not put any signature in the measure itself. We will not get the record, may not be and if the proceeding record, may not there I have given the handed over the possession to the court itself. So the court itself by handed this. Writ petition is filed immediately after final notification. That is filed on 10/10/2003. Final notification is dated 9/9/2003. Final notification of 7/11/2002. I have obtained conversion in the year 13/10/89 itself. After obtaining conversion, I have made a layout mirror. I have found the layout, explored the sites, 30 meters of land. That's why I told the BDA to apply this 13 meters, leave the 30 meters because I have sold. They have already, some constructions have come up in the person purchased the 30 meters. That's why I told them, when you apply 3 meters, 13 meters, I am not objection for acquisition. I have said. I clearly made the objection of. Writ petition filed earlier, I have stated.
But this is not the finding that you have handed over in the year 2004.
Yes.
Learned single judge does not say so that you have handed over. There is no finding, right, in your favor. Even though the order is in your favor, it doesn't say that you had handed over possession in the year 2004. Rule 3 is meant for those people who don't litigate. You are litigating also, filing a petition also, what the benefit also, everything. Why?
Because I requested the BDM not much prior to the notification after the notification. And after filing the writ petition, the BDA has promised that to review the 30 meters because it has been sold and acquired, it has not been.
How much of his land was notified, Mr.? And so entire 4 acres. Page
99. Schedule of the implement. 4 acres.
Because they are notified, I have to challenge the and that stated in the body of the petition.
So according to you, you had handed over possession in the year 2004. The company, so you are there, you have to tell us. Let the record come, why he will produce. It's your defense, right? After having argued the case, you cannot say that let them. Doesn't say. Huh? Where is it?
Page
10. No, it says that there is no material. To say that 2007 it was handed over. That doesn't mean it was handed over 2004. Then, and you received a notice under section 9 when? Yes. That's what you should do, Mr. What a case, more than 5 minutes, we are just noting it down. Then it was received. He should, right? He didn't hand over the position. And filed a writ petition when? When? 10/10/2000. 10/10. 10th of October 2010, he filed a petition. 10th of October. Yes, anything else? Has he handed over the possession in the year 2004? 2007 it was taken, right?
The topics are discussed. How the mileage are being used, how they are conducted and given of other. As is commonly known, there are visitors to some unknown printed formats, the blanks filter, and it is specifically claimed as a document establishing the taking order of possession. Such documents have been routinely negated by the court on innumerable occasions, and this is one more.
That's it. Anything else?
Actually, I that is not the reason they have to report the intent to $1. It will not be the number of the produced one expenditure of the income of the poor. The fundamental rate of the particular, the challenge is it will not come in the area of banking, but I predict along with me. The input that will pass.
Picture. The court has to find out which page. You will only tell annexure E. It's the court's duty to find out which page. Annexure E. Yes. What is it, Mr.? What order? That's correct. Supposing if in a writ petition there is no stay granted and in the meanwhile notice under section 9 is issued, he hands over possession, cannot be deprived. Yes, that's it. Thank you. Not even that thing. By Chandra. Like in their folders, they can open and type here. Why not type?
I appear for the respondent, my lord.
My lord, I appear for the appellant in this matter, my lord. My lord, I appear for the appellant in this matter, my lord. My lord, the respondent has filed a list of authorities and 2 circulars on 13/10/2022 along with circular, my lord. I have to seek instructions. Kindly have it next Tuesday, my lord. Next Tuesday, my lord.
No.
Regarding grant of stipend to the trainees and apprentice, my lord. I have to seek instructions in this, my lord.
Read the order. What instruction? Nobody can give you any instruction. If your client was supposed to teach you the law, I mean, then it's better that he himself appears. Last date of hearing also you sought adjournment. This is all, I mean, casually, but just like sitting there and saying that I am appearing for the appellant. Mere appearance does not matter. Who will argue the case?
Kindly have it on Friday, my lord.
Nothing. You are Mr. M. Pradeep. You
Please,
had
ma'am.
prayed for an adjournment on 6/1/23. We had
Please, ma'am.
granted adjournment. Nothing. Assistant for Provident Fund Commissioner. Yes, this intra-court appeal. Write down. Yes, Mr. Will you write or not, madam?
Yes.
You're not typing it by now. You should have typed that small order. Why are
Kindly
you
have it on Friday, my lord. I beg your
No,
lordship.
no, we are dismissing it.
My lord, kindly have it.
Record that you are not arguing the case. You will say whatever you have to say.
My lord, I
This
beg
your
your lordship.
petition has been your petition has been dismissed on the ground. Read the order passed by learned single judge.
Please, my lord, regarding maintainability, my lord.
Read it. We have not opened the shop. I mean, granting adjournments to anybody.
My lord,
Last
kindly.
year, no, forget about it. Don't stand with a begging bowl before us. We feel bad about it. Don't behave like this.
In the light of the order dated 14/2/2014, the RPFC in its order dated EPFO versus Indusville and another rejecting the petitions on the premise that the RPFC is neither a party nor a party to the list, but has acted as a quasi-judicial authority in passing the order. Subject matter of proceeding, this petition instituted by the APFC, calling in question the order passed by the appellate tribunal, is rejected.
What is the locus of a quasi-judicial authority to challenge an order? That's the issue. Tell us, what instruction will you seek? Nothing. We will reject it.
My lord, it is act as envisaged the RPFC and other officers determined under section 7A, my lord. He is competent.
Vijay. Yes. Yes, Mr.
Millard, respondent Millard.
Yes.
Millard, I mean, the two things can be done in this case, Millard. Now, in another writ appeal, this honorable division bench has held that the writ petition is maintainable. Therefore, it could be sent back to the learned single judge. It could be argued. Or on merits, I am ready to argue the matter.
No, we will send it. There is no adjudication on merits.
That's right, man. The division bench judgment I have produced, the division bench judgment following that.
Oh, Mr. Senior Counsel, unfortunate thing is that the counsel for appellant has not read it and repeatedly is seeking adjournment, even though you are willing to concede in his favor that such a writ petition lies.
The division bench judgment. I have produced the division bench judgment, my lord.
It is a division bench judgment.
At page 8, my list dated 28/9/22 may kindly be seen, my lord. 28/9/22, my list I have produced.
That's it.
That's page 8, my lord.
We will remand the matter, Mr.
Please, but that is holding that is maintainable. Page 8, the division bench order is produced.
All right.
You last may kindly see the question is answered at page 26, my lord, para 13.
Para 13.
Para 13, page 26.
Last paragraph.
Don't interrupt now. We had granted you an occasion. You did not argue.
The issue is framed at page 17, my lord, first issue. Page 17, ink page 17, internal page 10 of the division bench judgment, para 5.
It is not such a difficult thing, not such a difficult proposition of law, right? I mean, don't labor. We have understood, right, that it's maintainable.
Much obliged.
Nothing to labor. We appreciate your fairness and we must thank also learned counsel for appellant for seeking adjournment. What can we do? We have to thank him also. Last year also, last time also sought an adjournment. Today also he is seeking adjournment. We will say so.
Please.
This is the qualification that you keep on seeking adjournment. Yes. Right? Yeah. All. It's absolutely. Improvement. The court appeal has been filed against an order dated 11th of March 2014, passed by unit single judge, by which a petition preferred by the appellant has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that the Assistant Provident Fund Commissioner sought a writ of certiorari and challenged the order passed by the Employees Provident Fund Appellate Tribunal dated 12/6/2013 in a writ petition. Current single judge of this court, by an order dated 11th of March 2014, inter alia held that the Assistant Provident Fund Commissioner, being a quasi-judicial authority, has no locus to file a writ petition. He said the writ petition was dismissed accordingly. Paragraph. We have heard learning from parties that a division bench of this court, by a judgment dated 12th of January 2003, passed in WA number 6081/2001, inter alia, has held that the commissioner, inter alia held that the assistant commissioner, so and so, whatever, assistant provident fund commissioner has locus to assail the order dated 12/6/2013, passed by the Employees Provident Fund Appellate Tribunal. Full stop. Paragraph in lieu of a enunciation of law by a division bench of this court, order dated 11th of March 2014, passed by learned single judge, is hereby set aside. Full stop. The matter is remitted. Full stop. Since the controversy, since the merits of the matter have not been examined by the learned single judge, the matter is remitted to the learned single judge to adjudicate the validity of the order passed by the Employees Provident Fund Appellate Tribunal afresh in accordance with law. Accordingly, appeal is disposed of.
Much obliged, man.
And one more, give that also will finish. You sent all right to them in the lunch.
Much of it.
Yes.
इसके बाद गवर्नमेंट एडवोकेट एक महादेवन
हाँ. Right. 8 years. See, last year, this 6th of January, you had prayed time. So when will you mend your ways, Mr.? Someday it has to be argued, right? So tax is imposed. That doesn't mean that this court will keep the petition pending for indefinitely. Huh? No instruction. You have to prepare the case. Nobody will teach you the law. Your client cannot teach you the law. Otherwise, he would be here. No? Who will give you instructions? We will ask that authority to remain present. He will argue. You sit by his side and assist. Who will give you instructions? We will ask that authority to appear before us, so that he will give us the whatever he has to say directly to us. Why through you? 8 years you are already seeking time. Tomorrow, Mr. Nothing. We don't. 2014 matter, Mr. 8 years. So because court has said tomorrow, right? So you have to oppose.
No, man. Yeah.
Let it be. Why? We are not getting any increments in deciding. No, let it be. Mr. Let it remain pending. Why? No. Learned counsel for the parties once again jointly pray for adjournment. List after 4 weeks. It is made clear that no further adjournment on any ground shall be granted. So this is disgusting, right? To say the least, it is disgusting. See the last order. What? Sorry. Saturday and Sunday was there. It's not that, I mean, all of a sudden it has been sent to the fights. You were aware. And you know, the moment we will tell a date, the council will oppose. We say tomorrow, he will say tomorrow. If we would have said day after tomorrow, he would have said Thursday. Let it be. No, this court is not in a hurry, Mister. We have to. You are equal partner in the administration of justice. If you are not bothered about the case, why we should go? It's nothing. Nothing. It will come up after 4 weeks. Yes. 4 weeks. No adjournment. No further adjournment.
Number 52.
And we'll remember this week. Don't seek an adjournment. Don't like. We will start imposing cost on now. Any case 5 years older, you should be ashamed of yourself. Nothing to feel great about. Nothing. Nothing to feel happy that celebrating adjournment. That I have been able to seek an adjournment. We can decide this case itself without your assistance. Don't think that we need even you. We have taken oath, we can decide the case. But yes.
10 days. Filed by the husband. Well, one, yeah.
When was the petition filed?
So the night.
The section
Well,
is 12(1)(c). Table. But she was a minor. Then what is 12(1)(c) and
one.
A? What cruelty? What are the averments? What ground I mean it is solved? What humor? So this was 12(1)(c). These two ground. It's 12(1)(c). What is the cruelty? Cruelty. What have you pleaded me? Therefore, appeal should be allowed. This is final hearing of the appeal. Can we write a judgment in which you are arguing in the manner in which you are arguing? Why it has been dismissed? Acha, Mr. He's a young and inexperienced fellow. He doesn't know how to argue in appeal. You tell us. So marriage was performed on, sit down, relax, enjoy life. Yes. So marriage was performed on 17/6/2007. Yes. Then on. Sit down. Nothing. You have done right. Your best. Sit down now. Yes. You have to write judgment. We are hearing you. You sit down. Relax. You have done your job. He is 59 years and she is 55. That's the argument. Yes.
He did not take his wife. He returned to from Saudi Arabia on 28/2009.
30th October 2010. Where did he go to Saudi Arabia? And so,
his petition for president 23.
which paragraph, Mr. of the petition, you have to show the averments from the record, which paragraph? What has been said?
Attending the family function at the petitioner's family house at Tara of Kakalakal in the month of 2008. On that day, the respondent behaved childish manner and insulted the petitioner's younger sister, actually, that she has not conceived any child, and that the petitioner is also not suitable for the respondent. In the presence of all the and they gather and she has taking that artificial petitioner is not practically and the family but
Yes, yes.
Separation of the material of fact that the petitioner submits the control.
Which para, Mr. So you should tell us that this paragraph he has avert cruelty, this paragraph he has, this is 12(1)(c). You should tell us what is, then your response, what witnesses have said, what is the finding of the family court? Tell us. Separation. No, it's not a separate. He has not sought any ground decree on the ground of desertion. Yes, desertion he has not sought. So 12(1)(c) he has said that what is the averment that you had entered into an earlier marriage which resulted in divorce, and where has he said that you had assist, underwent surgery and this thing, and that's why it is voidable? Where is that pleading? Simple.
The same material was conceived from the petition. My thought under the circumstances. Will you see? Earlier marriage was separate, and that the removal of the was also separate to the 50. The on this track will give you a parity that they are the petitioner and responsible.
What is your this thing stand in this? What did you say? No, perhaps we are not clear. I mean, all we want is that please show the averments where he has said about the grounds pleaded. What is your objection? Where have you denied which paragraph and the finding? That's all.
And
Para 11 also.
Paragraph 14 is about the cruelty. Mental cruelty.
What cruelty? What is the pleading? I was saying cruelty. Please read it. You know how he has argued. He has said 58 years, 55 years. Therefore, decree should be granted. What cruelty?
Family, that is cruelty. That is what.
No, that is not a ground. Yes, nothing. Yes. So what is the evidence adduced with regard to your previous marriage?
Actually, we had money, because they are related. Petitioner and the respondent, the relatives, had the knowledge of the case. That is like the paragraph 20 of his professional community. ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಹೇಳಿರುವ ಡಾಕ್ಟರ್ ಮಂಜಯ್ಯ ಶೆಟ್ಟಿ ನನಗೆ ಮತ್ತು ಇಬ್ಬರಿಗೂ ಸಂಬಂಧಿಸಿದ that means that we are related of Dr. Manjay Shetty. ನಾವು after the category ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿದ್ದೇವೆ. ಎರಡು ಸ್ಥಾನಗಳ ನನಗೆ ಮಾತು ಮದುವೆ ಸಂದರ್ಭದಲ್ಲಿ ಎದುರು ಕುಟುಂಬದ ಹೇಗೆ ಬಿಟ್ಟುಕೊಂಡಿದ್ದೀವಿ. That gathered information about the family of the wife and consented the marriage was performed presence of the elders. He said, then after he said, he has stated that the paragraph was 38, we got it in Kannada. Need to be removed. And we bought exam. Then I have come to the ಎದುರುದಾರರಿಗೆ ಮಟ್ಟವಾಗುತ್ತಿರುವ ಜನರು ಈ ರೀತಿ ತಿಳಿದ ನಂತರ ನಾನು ವ್ಯಕ್ತಿಗತ ಅಭಿಪ್ರಾಯ after I came to know that she cannot be conceived, I have decided to fight this petition. And in the judgment of this petition, that is the petition has admitted that the family background pertaining to the response at the time of the And hence it's very, the consent of elders on both sides. And the relevant portion is extracted. Then could be medical condition. This is what we stated in paragraph 70. Of course, there is an increase in the evidence. And not having that there was suppression of the condition of the was not petitioner. Therefore, the raised in the petition is not accepted. And the district maintenance is not paid so far.
You execute the decree, what's this? Yes. Yes. We are coming. Why? You also have to seek instructions like government had. Huh? Why? Get the file from him. There is nothing great about this. You take the file. This is not the time. It's not the time to seek adjournment. Not a good idea to detain the court when court is rising and to seek adjournment. We would have understood if you would have requested that urgent, I want to argue right away. We will sit till 2 o'clock, but not for an adjournment. There's nothing great about adjournment. You go whatever, wherever you have to go, we will decide. We have taken oath, we will do justice. Fine. We have to write the judgment. Nobody else. Right?
Court officer? Madam, court officer? Madam, ಲಿಸ್ಟ್ ಅಜನ್ ಆಗಿದ್ಯಾ ಇಲ್ಲ ತಗೊಳ್ತಾರಾ? ಕೇಳಿಸುತ್ತಾ ಮೇಡಮ್? ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಎಲ್ಲಿಗಂತೆ ಬರ್ಕೋತಾರೆ ನಿಮ್ಗೆ? ಯಾರೋ ಮಾತಾಡ್ತಿದ್ದಾರೆ?
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಮೇಡಮ್.
ಸರ್ ಲಿಸ್ಟ್ ಅಡ್ಜರ್ನ್ ಮಾಡಿದಾರಾ ಇಲ್ಲ ತಗೊಳ್ತಾರಾ?
ಎಲ್ಲ ತಗೊಂಡ್ರು ಮೇಡಮ್. ನಿಮ್ ನಂಬರ್ ಯಾವ್ದು ಹೇಳಿ? ನಿಮ್ ನಂಬರ್ ಯಾವ್ದು? ಸೀರಿಯಲ್ ನಂಬರ್?
Sir,
serial number 31 list 2.
Appeal 825 of 22 ಅಲ್ಲ ಮೇಡಮ್?
ಹೌದು.
This along with 835, 837 of 22 on 30th January.
Okay sir, thank you.
Court officer?
ಹೇಳಿ.
Sir, first court ತಗೋತಾರಾ?
ಆಯ್ತು ಹೇಳಿ ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್?
Sir, counsel for the party once again pray for adjournment.
Serial number 4
List after 4 weeks. So it is made clear that no further
23rd
adjournment shall be granted
ದೇವಡಿಗಲ
on any ground.
ಹೌದು ಸರ್.
1 week to amend the cost title.
1 week. Sir, serial number 15 sir, please to.
2 ಮಾತ್ರ ಹೇಳ್ತಾ ಇದೀನಿ ಮತ್ತೆ
List serial number 15.
4 weeks.
15.
Yes sir.
Chatabesh Shivana. 1 week. 1 week to comply with the office objection.
Okay sir, thank you sir.
Counsel for the party
Lord. See that? Now continue. Rupa. Up. 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 Oh, it's continuing, right? Number 53.
I appear.
Yes.
Sorry, my lord, Mr. Vikram mentioned that he is going to mention a matter. That's why I was here.
So he said he has informed you this thing tomorrow he wants.
Yes. If it's tomorrow, I have no objection, my lord, because that interim order is hurting us.
Yes. All right, tomorrow, Mr. Argue. Yes. Tomorrow, Mr. Nagarna.
Please, my lord, please.
Number 54. Kumar and Sriram Reddy.
Please appearing for respondent. 3 days. Why? Today probably is a good. We'll just take it over. Pass around. Please wait.
But 55.
Yes, madam. We will tell you what is it about. Don't worry. You will also learn. No. By that time. No. 1 hour, right? You are mentioning at 1:32 minutes past 1 o'clock. And 1 hour and 10 minutes have passed since then. What is the progress have you made about this? Tell us what ground you are this thing petition has been dismissed or allowed? What has happened? Petition has been dismissed or allowed? Who's the appeal? Why, sir? The petition filed by the husband has been allowed. What ground? Desertion and cruel. So when was the marriage performed? You don't have filed. So that's why we told you to have the court record. Don't know that you should take it from him. See, taken. So no, nothing. When was the marriage performed, madam? Now tell us. Start reading judgment. And in the eventually, after having argued the matter, you will realize that it's not so difficult, right? There's nothing in a matrimonial appeal for which you should seek adjournment. Same problem will happen tomorrow also. So why not? I mean, surmount the obstruction and problem today itself. Nothing. Tell us, when was the marriage performed? In 599. Any children born out of one child? Son, daughter. When was she born? Oh, 13. So since when you are not residing together? 2002. You are forced to leave the matrimonial home, right? Huh? So what did you do? Did you file any application? No, no. You were forced out of the matrimonial home, right? Huh? Thereafter, did you file any application under Section 9, or did you send any notice saying that I want to join the matrimonial home, I've been thrown out? What did you do? Respondent. Husband. When was this filed? When was 2003 and 3? Right. Yes. When? When? Find out the record. What was held in that case? When was this seeking dissolution of marriage? 2013. So what was this thing pleading with regard to desertion? Which paragraph of the petition? Which paragraph? Which
She responded me. He got back he got back so he said that Parliament so she is intended to take more than the report that should see that and see that fiber after that actually cannot stated why she did what is the player he had not stated when he became pregnant and doctor. The patient has said that no children were born. The report of the he would have
That's all. See how simple it is. Why this you had to do? You would have done tomorrow is better. Yes. Thank you. And where is the respondent counsel? He relied on you and went away. It's up, whatever happens. Yes. Right this. Yes. $20. No, this and she that she left the matrimony one day after. You believe that she was thrown out after she didn't give any notice, not like
She contested his petition for section 968.
Fifty-six, A.B. Narendra Prasad.
little. Can report settlement here also. Huh? How much time? 2 weeks. All right. 56 learned counsel for the parties jointly submit that the dispute between the parties is likely to be amicably settled. It is further submitted that the parties are ready and willing to appear before the Bangalore Mediation Center on such day as this court may direct. Paragraph. In view of aforesaid submission, parties are directed to appear before the Bangalore Mediation Center on 18th January 2023 at 3 o'clock. Son is aged about 21.5 years. And what about daughter?
January 2005. For restriction of fundamental rights, I was ready to rewrite and look at the
When was the petition filed?
2005.
26/2005.
Dated. 5/2/2005.
Petition under section 9.
9.
What happened? We have the date when it was withdrawn. All right. So after what? Uh, 31st July 2006.
two small children. He took away my son. Therefore, I was afraid for peace and see my child my custody. But the son is living and now the son is custody. He threw me out. Thereafter, I didn't go out. I was seeking my son's custody with me. He was the price of case. And I was dismissed as before, not on merits. If he was ashamed, he used to be writing him. He was not taking it back. So he was practicing. Immediately, because of the prices, there are, is there any genuinity in this case? I have any the court member, he is not want to be. He does not want to be any with me. He has a fear of me. Where is the fear? I will just read out the evidence that he has taken. Was there any difference between two options? He said, so there is no now ಬೇರೆ ಯಾವ apart from her going equally to parents, two other differences between us in the statement. Thinking I go to my parents, staying in Mudhol, different districts, she's saying they're not in Bangalore, but wasn't any material or record to show that whenever when did he come, when did he take it back? After that, deciding to get on top of dispute. She has denied her, I am not going to get herself. The reason we are after marriage with 2 children, I am hired 2 children. I think for delivery, I stay for the delivery. Postpartum care, I was with my parents. 2 years, I had the second child. It came back with the delivery. Then I spent in my business. He told me about the house. I was reporting to I was neglected in the house. In the parents, I was living with his parents. He has made alleged that I was coming in between his parents, trying to instigate against him and his parents. All this has not been given. The grounds that has been urged. I was not well. I had mental health condition. That was the ground that was being used. In the entire petition, it says that I was ill-breathing in presence of public, where public, which public, very oily and vague allegations are made which are not substantial. In the apart from this evidence, no other evidence is being placed. This is more evidence substantial. I think have very good order sheet. Because the court comes to the conclusion, I am very good to say him. He is not ready to say with me. All of my husband very much. I want to either provided in now, for this may not be the examination what I'm saying. Even now, she's ready to try with me. I am not ready to do. The reunion is by being produced by whom the person asked myself. My fair. So the output of what find fault with me and say that I was responsible for this. None of the allegations are substantiated. Any grounds of activity has not been discussed before. On the other hand, even the ground that restriction is there, therefore reunion is not possible and it's supposed to be. I'm here. I'm ready to stand. He does not even provide a pay any maintenance for the child. For his pay. And where that before the COVID, we had before the COVID, they could not use to happen. However, now, 4 years, I know means I know depending on other means. Asking for 30,000 rupees. For the granted 10,000. He has 2 children, 5 his parents. He was at the time when the patient was 5, salary is claimed. He had 5 children, he was working as a manager. In the past many years, he is much higher post in the salary per month. That is maintenance when our child's education, how would I was studying engineering college. I have to support the child's education, the daughter's education. To provide for the child, a female child, till she gets married before studying and still other than providing 10,000 anything. Therefore, my lord, enhancing being done for As a meditation, I have not got. The moment today, I have not got. Based on- Because of the fact that he should plead and prove what is cruelty. When it is not proved, the court cannot, on the ground that there was no union, grant the cruelty. That will not happen.
Oh, so what happens if your appeal is allowed? The judgment goes, right? Judgment goes, including 10,000 also goes. You are at liberty to seek whatever amount you have to pay proceeding. You succeed, it's set aside. Yes. Huh? Say whatever you want to say right now, madam. It's not, I mean, she argued the whole case, you did not say anything. You were standing, you didn't say. What next week? What next date? There's no next date. This is the last day of this case in this court. So no next date. So you say whatever you want to say. Okay. No, not after having she has argued the matter. Why? Why? Then what were you doing when she was arguing the case? Why you did not say in the beginning that I want an adjournment? Did you say? Did you tell us that you want an adjournment? No. This is too much, madam. Since how long you are practicing? No. 3 years. How many years you are practicing? 3 years. Good enough. Good enough to become a civil judge and you don't know. Person junior to you have become, we have recruited them as civil judges. You don't even know this. You will have to learn it the hard way. When you will get the judgment today itself. Be happy. There is no next date. You should. No. So I mean, we tell you only this, then you will argue, right? So just taking chances, right? You thought that supposing if the court is against her, so I need not do anything. So then you thought that probably court may allow. So then you are saying I will argue next day. When we will say that you will get the judgment today, then you are saying that I am ready. So we don't like. We don't. Unfair, madam. To say the least unfair, your conduct is not becoming of an officer of this court. We put you on a high pedestal, right? Everywhere you see that advocates are officers of the court. This is how you assist us in administration of justice. No, you should be ashamed, madam, of yourself. There's no question of tendering apology. We want that you should feel ashamed of yourself for conducting you in this manner, right? Yes. Anything? No question of you argue, madam. If you have to say anything, you say. The judgment is being passed today, now itself. There is no next date. Don't be a scene tomorrow. Yes. What is the evidence of cruelty? What is the pleading? No finding. What is the evidence? What is the evidence schedule that she used? When did she go?
There is no reason to sign. Most like my boss, definitely become confident rights petition.
That's what we also think, that no reason has been assigned by the family courts for allowing your petition. No reason. What is you had confined your prayer for dissolution of marriage on the ground of cruelty, is it not? What is the cruelty? Where is the finding recorded by the family court that you have been treated with cruelty by the appellant? Which paragraph is the finding? Tell us. There's no finding, madam. That means you have not read it. That means you have not gone through the judgment. There is no finding. No finding about cruelty. Right. Para 23 is the only judgment. That's it. All right. That's all. This appeal. Yes. She is willing to join. She is willing to join. You have admitted that I don't want to stay with her. She was ready to join.
Even though she didn't attend to mediation and it was paid completely megos. Later on, after waiting for 7 minutes, he filed a petition for divorce in 2013. Only reason that she didn't get in, and the mediation also she didn't attend. In 2005, when we left the mediation. So hence we filed a petition for divorce of the divorce. And the decision was the main reason for divorce petition.
Surprisingly, you did not press the petition on the ground of desertion. That would have been understandable. Why did you withdraw your petition under Section 9, madam? You are interested. That's why you withdrew the petition. Then why did you file if she was not interested? The question was put to her in your cross-examination that she is ready and willing to join you. You said, no, I don't want to stay with her. That That's it. Anything else? Yes. Yes, appeal. Huh?
Immediately after withdrawal, they filed a case in 2006. Then I transferred and renumbered as the problem.
Yes.
One of the and then it is a good show.
It's appealed under Section 19 within bracket 19 of the Family Court Act 1984 has been filed against judgment dated 16th of July 2015 passed by the Family Court, by which petition filed by the respondent under Section 13(1) within bracket small Roman 1 and -A of the Hindu Marriage Act has been allowed, and the marriage between the parties has been dissolved by a decree of divorce. Facts giving rise to filing of this appeal briefly stated are that the marriage between the parties was solemnized on 5/2/1999. Full stop. The children, namely two children, namely a son and the daughter, born to the parties on 10/5/2001 and 19/10/2003. The son is in the custody of the respondent, whereas the daughter resides with the appellant. Full stop. admitted the parties are residing separately since 30th 1 2005 paragraph. The respondent filed a petition seeking dissolution of marriage on or about 5th of February 2005. No, on or about 31st of July 2006. 31st of July 2006, inter alia, on the ground that the wife left the matrimonial home along with the daughter on 30th January 2005. Full stop. It was the marriage of 30th January 2005, right? The along with the daughter. It was averred in the petition that the respondent, it was averred in the petition that the appellant used to visit her parents' place frequently without any intimation to the respondent. Full stop. Stated that the appellant is not mentally sound. The appellant, therefore, the respondent, therefore, sought dissolution of marriage on the ground of cruelty and exertion. Paragraph. The appellant filed the state paragraph. The appellant filed the statement of objection and objection in which the fact of marriage was admitted. It was further admitted that children were born to the parties. Full stop. It was pleaded that the respondent had thrown the appellant from the matrimonial home and thereafter had filed a petition under Section 9 of the Hindu Marriage Act on or about 5th of February 2005. It was further stated that the appellant made a statement in the petition filed by the respondent under Section 9 of the Hindu Marriage Act that she is ready and willing to join the matrimonial home. Thereupon, the respondent withdrew the proceeding under Section 9 of the Act. It was also full stop. It was denied that the appellant has treated the respondent with cruelty. That is submissions, right? In the petition previous paragraph, we have said to go to parents' house without informing. It was also pleaded that that appellant used to humiliate the respondent in public places. That's it. Public place. Paragraph. The family court. Paragraph. The family court, on the basis of pleadings of the parties, framed the issues and recorded evidence. The respondent got himself examined as PW1 and exhibited 12 documents, namely Exhibit P1 to P12. The appellant got herself examined as RW1 and produced the salary certificate annexure R1. The family court, right, judgment and decree, family court, full stop. In full stop. The appellant, the respondent confined his claim for dissolution of marriage on the criminality. Full stop. The family court wide judgment dated 16th of July 2015. Inter alia held that that no useful purpose would be served if the prayer of the respondent for dissolution of marriage is refused, as the mediation for reunion in the parties has failed. It was accordingly, it was held that the respondent is entitled to a decree for dissolution of marriage on the ground of cruelty. Stopping the aforesaid factual background, this appeal has been filed. Paragraph. Learned counsel for the appellant submitted that learned counsel for the appellant submitted that the that the appellant is ready and willing. Even now, the appellant is ready and willing to join the matrimonial home. It is further submitted that in fact the appellant was driven out of the matrimonial house on 30th January 2005, and in the proceeding under Section 9 of the Act initiated by the respondent, the appellant had made a statement that she wants to join the matrimonial home. It is further submitted that the attention of this court The attention of this court has also been invited to the evidence of respondent, wherein he has stated that he is not ready to reside with the appellant. Full stop. It is further submitted that no evidence has been adduced by the respondent to prove the ground of cruelty, and therefore the family court here, without assigning any cogent reasons, grossly erred in granting the decree of dissolution of marriage on the ground of cruelty. On the other hand, learned counsel for respondent has supported the judgment and decree passed by the family court. Paragraph. We have considered the submissions made on both sides and have perused the report. The cruelty thing, ordinary wear and tear, this thing, right? That paragraph in the backdrop of, you show me once, paragraph in the backdrop of aforesaid well settled legal position, we may advert to the facts of the case in hand. Full stop. From the full stop. In the admittedly the respondent had confined his claim for dissolution of marriage only on the ground enumerated under Section 13(1) IA of the Act, that is cruelty. Full stop. We have carefully perused the pleadings made in the petition. Full stop. No specific instances of cruelty have been pleaded by the respondent, except by stating that respondent used to go away to her parents' place and insulted the respondent in public, and the appellant insulted the respondent in public places. Full stop. From the evidence of the respondent, also it is evident that he has not furnished the particulars. He has not furnished any particulars with regard to he has not narrated any specific incidents with regard to cruelty, and have made general and vague statements in his evidence about the appellants leaving the matrimonial home and and by stating that the appellant used to insult the respondent in public places. Paragraph. The family court from perusal of the judgment of the family court, also it is evident that the family court has not assigned has no have family court on the basis of evidence adduced before it has not recorded a finding that the appellant has treated the respondent with cruelty. Para 23 of the judgment reads as under quote paragraph from the perusal of the aforesaid judgment, it is evident that family court has granted the decree of divorce on the ground of cruelty, only on the ground that there is no reason to refuse the prayer of the respondent, and therefore he is entitled to a decree of divorce. It is full stop. The from the pleadings of from pleadings as well as from the evidence on record, from the statement of from the evidence of the respondent, no ground of cruelty is made. Neither any ground of cruelty has been pleaded, neither any specific ground of cruelty has been pleaded, nor the same has been proved. Full stop. In the family court, in a cryptic and cavalier manner, without assigning any cogent reason, has granted the decree for dissolution of marriage, which cannot be sustained in the eye of law. It is accordingly set aside. 9 below in the result, appeal is allowed. How can that be sustained, madam? That's what we told you. How can it be sustained? We can't time it, yes? You are at liberty to take risks. Execution. We don't know, madam, what. We have stopped advising the clients. You are competent enough to advise what to do. Yes. What is Minutes. Exhibit P1.
The second plaintiff was born on 1969. That is Chennai Keshava case. Her mother name is given as the first of all,
And father name is shown as the respondent. He was born in Bangalore, MS Ramaya. The 3 dates are very important as far as the P1 is. But it's 2009. But it was registered on 30th June 2009. Never
This is right. This exhibit P1 is dated 30th.
But it's dated 27/7/2009. It was issued on 27th July 2009.
Yes.
27th July 2009. Date of registration is 30th June 2009. Date of birth is 19/6/2009.
Date of registration is
30th June 2009. Within 11 days. It's not an after fact, it's not a obtained after filing the case. It was the immediate document available as per also. The exhibit P8 is the election identity card dated 1/1/2002. That shows that respondent system of the husband.
1/1/2002.
1/1/2002.
Exhibit
P8 election identity card. P8 identity card.
What does it show?
So our husband name of the first of all, the respondent. Second is Muniraju, son born to respondent through his first wife. And the second occurrence, Keshava and parents. Exhibit 3 is very important documents.
Exhibit
P10. If the yours refilling receipt, the name of the respondent husband of the first.
the name of the appellant.
Respondent husband of the first. This address tallies with the address of the exhibit P8 and the P9. The second appointment was called on 1969. Yours refilling receipt was issued in the name of the other on 3/11/2009.
3/11/2009 is what?
Yours refilling receipt, yours delivery receipt.
Which exhibit?
Exhibit P10. P10.
So,
This was dated November 2009. The birth of the first 2009. At the time of birth of the second appellant, the respondent was very much educated in family.
yes.
P13 second claim.
P
13. Second claim. Then
NCR 8 to 9. The presentation of the plaintiff phase, the respondent has opposed the first plaintiff to get the delivery of the claim. After the case was filed on 19/6/2009, the respondent and his first wife have raised their quarrel and they are given the complaint. The police have settled the issue and they have issued a NCR for the waiting. So this is subsequent to death or birth of the second plaintiff. Finding of the tribunal is, if at all the dispute arises, it cannot be a part of the material on the record. Exhibit C11 is also one of the important documents which was finding of the wherein the first plaintiff has purchased their property. Along with the money value, son of the husband or uncle his first wife. Wherein thumb impression and photo of the first applicant is affixed. His signature photo has been identified by the respondent by misusing the helplessness of the has told the name of his first husband by name. He tried to mislead and photos he has identified. This was very much close to the date of the course of examination. He has identified the photo of his son born to first wife, whereas in the photo of the first plaintiff, the first applicant is shown, he shows that my eyes are blinked and I cannot. So it is intentionally you try to avoid the action of the this thumb impression is not through the author of the document to the subject office. It was common. Exhibit C12 is generic. In the sale deed also, the respondent husband is one of the witness to the sale. Somebody he has signed the witness. As a witness to the sale deed agreement. You will be in the position. Some person maintained the C12 with sale. As far as signature in the agreement C12 is concerned, the respondent answered that I used to sign my name as Krishnamurthy alias Madhyappa and did not sign as Krishnamurthy. This is the answer given by the respondent. But as far as in its examination sheet itself, in several pages at KW1 examination period, at one page he signed instead of Krishnamurthy. And in other portions, at page number 11 of the staff exam, before you said, he has tried as Krishnamurthy and also as name. So testimony and also there is not an acceptable testimony. He has to avoid escape from the payment of maintenance to the wife. And that too is paid or under second. Several documents were placed. Even the plaintiff has filed an application before the airport or DNA examination of the case. Yes, raised an objection. If the second plaintiff is not a clear warrant respondent, it did not have opposed it. Right? The application, we are not telling that already possible by the trial. We are raised that is the appellants are even from the one of the very important questions posed by the PWR during the course of process on behalf of the respondent is, which strange question has been posed. At page number 9 of the cross-examination of the PWR,
The respondent is A, he is suffering from diseases, he cannot give birth. That is one of the questions posed to the plaintiff, PW1, he has specifically denied the person for budget. They have marked the several documents, even what the PW2. One of the specifically the respondent was not residing in this first one. There is a specific admission of the respondent meeting. The evidence of the several agreements of the respondent meeting. Yes, I will ever do the three important points. Page number 12 with regard to avoiding identification. So I did not get it. This is clear and digital photo of and he has denied the photo of his first line. The second admission is the question is for the first plaintiff and is the son or the first wife have jointly purchased the property, but he says that I do not know. Even regarding NCR issue, given by the first plaintiff to the police station, he says that I do not know. Even the complaint also is says that I do not know. Even one of the photos also shown to the respondent, positive photo of the plaintiffs with the respondent and his first husband. He says that I am not able to identify. I think it may be created. That is one of the answers given to the respondent when the court is coming. And a very strange admission made by the respondent. At page number 9 of this cross-examination. Regarding his first wife, he himself has given an admission. Muniyamma or Sarojamma, that is his first wife. Again, not related. He admits that first wife is not residing with him. And yes, that is the admission given to the. And one of the strange attitude of the respondent, he has obtained one death certificate of his another son by name Venkateswara. That question was posed to him. He has obtained a false death certificate showing that his son Venkateswara. He admits that when the Devaraja regarding obtaining a false death certificate, that's a clear admission. His attitude is always he is trying to make a cheating and honest attitude with respect to his son and also to wife. Son meditation is concerned with his son born first wife. He has obtained a false death certificate of his meditation. Subsequent, this is the state at the time of penalty. Subsequent document I have not put it here. Inquiry was made, the certificate was canceled. Now, when it petition before the son of court, subsequently it was withdrawn. Now the document I have not done. As far as I will stick on to the document. Even and also there is not a much material. Page number 12, second paragraph. As far as exhibit So safety is concerned. First one was for you have put your signature as a witness is denied this to the suggestions put to the DW1 the ನಿಶಾನೆ ಹನ್ನೆರಡಕ್ಕೆ ನಾವು ಸ್ಪಷ್ಟ ತೆರಿಗೆ ಮಾಡಿದ್ದೇವೆ ಎಂದರೆ ಸರಿಯಾದ ಸಜೆಷನ್ ಗ್ಯಾಸ್ ಡಿನೈಡ್ another suggestion is ನಾನು ನನ್ನ ಸಹಿಯನ್ನು ಕೃಷ್ಣಮೂರ್ತಿಯನ್ನು ಮಾತ್ರ ಸಹಿ ಮಾಡುತ್ತೇನೆ ಆದರೆ ಕೃಷ್ಣಮೂರ್ತಿ ಅವರಿಗೆ ವಿನಿಯೋಗ ಸಹಿ ಮಾಡುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಾದ but it's much there is that I already argued that I don't like to stress on. One more question posed at page number 40. And it's broken. In first, in the para number 9, he admits that I have paid against the company. And one now, they were complaint in this regard. Now in para page number 14, he says that I have no son like that. PW2 is concerned with that. Income and this by considering the relationship and also the attitude of the respondent as no woman will come. But candidates hope from this record maybe take the Court finding it second by this not intended from it. As far as the claim is concerned, found the reasoning that also not being given make it right. That a woman cannot go and claim that he is my husband unless that is you have to make much more arguments. Very clear. Respondent second claim. We are worrying about the second plaintiff which the minor is for future has to be taken into consideration. The respondent is the father of the second plaintiff. It is much more important. For this other is a concern. By column number 1 itself is not maintained. Because in the very plain itself, second para, she says that for plaintiff is the wife of the defendant, their marriage has taken place in Shanti Mahatma temple for 25 years ago. The first defendant was already had a wife. So when my lord first marriage is subsisting, the alleged contacting of second marriage does not. So the suit framed my lord claiming maintenance itself is not maintainable. Claiming maintenance and as well as for creation of charge for the property. Itself is not maintained. The plaintiff, my lord, as the evidence. The first plaintiff says 25 years ago, my lord, marriage took place. No date of marriage is mentioned. And my lord, she admits in her cross-examination that no, my lord, Shastras were followed while contacting the marriage. Lord, in the light of this admission, my next condition is that my lord, the learned trial judge rightly, my lord, and yes, my lord, produced. The plaintiffs have produced my lord various documents all those are the defendant is a Archaka of Shri temple, my lord, Shri Mahatma temple at Nonavinakere. Sorry, Narayanakere to Tumkur. The plaintiffs are, my lord, claiming right, my lord, over the claiming as wife and son. And my lord, their address is shown as Bangalore. She says, my lord, I also decided that Narayan. No documents have been produced, either the voter list or election card of that place. I think, my lord, the resident of Narayan, an Archaka in a temple. Question of why coming to, she also stated that for some time I decided that when no documents have been. Documents produced birth certificate, school record, it can be not by giving a declaration, anybody can obtain the documents. It has to be not put into the test of examination or the basis of the evidence, not it has to be established. None of the documents have not produced by the not established that not she is the primarily she has to establish that wife, first wife. That having not been established, not producing the documents in the name of son would not establish her case. And learned trial is not rightly. In Piano 20 of the Manor, they passed by the learned trial judge. With regard to the sale deed Manor, it is in the name of Manor, the first of my wife, Rojan, and the right. Only photo what to get defeated in favor of plaintiff number 1. Later on, no, it is not so. Sale deed is in the name of Lord plaintiff number 1. Sorry, my wife Sarojamma and son Munira. And my lord, in my written statement, my written statement, my lord, clearly stated in paragraph 5 of the written statement how the properties, my lord, have been, my lord. Item number 1 to 4. Item number 1, scheduled properties is self-acquired property, and he has gifted to my lord wife Sarojamma as per the deed 36/2009. And other properties belong to his brothers, and there are heavily partitioned, and some of the properties are given to the child born to my lord Sarojamma. So, with regard to the sale segment committed, if there are 20 of the trial judge has given a detailed finding as to how my lord it cannot be believed that my lord sale deed, the contention of the plaintiff number 1 that it was executed in her name, was thought to be executed in her name is false and incorrect. The learned trial judge had, my lord, has given a finding in paragraph 14 that, my lord, the how, my lord, evidence of PW1 and PW2 are contradictory to each other, and they have not established their case, and clearly stated like this, my lord. The plaintiff ought to have examined her neighbor either at Bangalore or at Narayanakere to prove that she and the defendant lived together as husband and wife. So when my lord, her marriage itself is not established, the question of claiming maintenance does not. So far as DNA test is concerned, my lord, we have from our client. Even today, we are waiting for real limited. This man is also having 75 vote. She was planning, she was already at the time of filing. It was shown at 60 years. The name of plaintiff number 1 is 45 years. The question of contacting the marriage, second marriage, does not arise. In the light of the parod, yes, pleaded and proved by. Now, my lord, the whole aim of the my lord filing this suit is my lord to claim partition in this family problem. Now, the second plaintiff has already filed a suit for partition before the trial. My lord, in the light of the findings clear and the learned trial judge has given my lord, the family judge has given a detailed finding by discussing the evidence rather than my opinion. And is given a clear finding that my lord may draw my lord's kind attention to the issue raised by the learned trial. At page 8, internal page 8. There are the plaintiffs prove that first plaintiff is the second wife and second plaintiff is the son of the defendant respectively. Whether the plaintiffs prove that the defendant has neglected to maintain them, whether the plaintiffs are entitled for maintenance. In the negative. All the three issues, my lord, that it is the negative. Issue number 4, creating charge of the negative. All the oral and documentary evidence have been discussed, my lord, in detail, and findings have been given, my lord, by the learned family judge. In unequivocal terms, that my lord, plaintiff number 1 has failed to prove her marriage, and as such, my lord, rightly dismissed by the trial. May I, your lord's kind attention to the '88, 530. But under section 5, conditions have to be not fulfilled, not for establishing the marriage. Otherwise, why the marriage under section 11 of Hindu Marriage Act? So, 125. Hindu when married after coming of the Hindu Marriage Act 1955, in accordance with Hindu rights, the Hindu male having a wife living held not entitled to maintenance and then my lord, the second ruling is the DOT 20 PR distributed Narayana. In that case, around PR 23. Second one, my lord, PR 23. It also specifies that any determination of the validity of the marriage the parties could have been made only by a competent court in appropriate proceedings by and between the parties. In all, with all other requirements of law. Mere production of a marriage certificate issued under the Digital Marriage Act in support of the claim first marriage of the apprentice was not sufficient for any of the courts, including the High Court, to render a complete effective decision with regard to the marital status of the party, that too in a collateral proceeding for maintenance. Consequently, we hold that in the present case, until the invalidation of the marriage, the appellant is made by a competent one. We don't we correct it on the basis that appellant continues to file. But she has to file a case for declaration that she is wife, first wife. Then only she can, if it is established. Next one, my lord, third one is Lord, section 25. So when the marriage is a nullity, firstly, my contention is my lord, he has failed to establish that he is divided. Even if she has to pronounce it by and then my lord, she can claim whatever rights under the law if she is entitled. And now his plaintiff number 2 has already approached the civil. These are learned fellowship has given an elaborate and correct pending. Okay. Yes. That PW2 is in the extent of the training of the PW3 is in my of comes from the principal office. Yes, sir. Here is that to the PW3, person is most aware of that photo can be requested by anyone. Yeah, it has specifically designed. Meaning of the photo is 11. Only the photo and thumbnail present in exhibit P11 belongs to thumbnail photo and thumbnail present has been identified. Well, as far as the declaration is concerned, which is not for declaration, she has totally created in the saying that after the marriage, I came to know that he had married exposure. Hence, instead of seeking declaration as a word of name declaration as possible. And as far as declaration of second wife is concerned, it is not maintained on the. That's why my she is not only a declare that first prejudice is entered for maintenance. And second prejudice is maintenance for so on. So declaration has come out by the she cannot maintain this one, even though she is really maintenance. Admit that the itself is not maintained. It will not be. But we can't take anything. Because that's not what we are already how is it? For 59, is Prasanna Kumar.
Please do. That's been. Set aside the degree. Yep. 1 minute. Which case?
59.
Yes, madam.
If pension tax me not
Ah.
already.
he has to pay 8 lakh. Out of 25 lakhs, then the amount every year. But that he has put it was 70 lakh. Believe that they will pay the extra year. So far, they are not paid 8 lakhs of 2000.
She says that, I mean, she has made an offer to make payment of a further.
Because we are paying more than the amount in the world. He is studying after studying PhD and studying. He is a lawyer. But he is a lawyer. He has treated like anything. Wherever he go, he open the.
Oh, that's what is often. That's what is offending, right? That your client is a lawyer and she has been cheated. That's what is offending. Nobody can. So nobody can cheat a lawyer, right? Yes, madam. How can you cheat a lawyer? Cheated. No. So we are on the this thing quantum, right? So family court has just a minute. Family court has awarded 25. She's offering another sum of 3 lakhs 17 she has paid. That you also seek instructions, right? And how long if she does?
He is studying both are studying, she is something like anything. Now she not starting the. He's something like because in one day she has totally about Italy and Italy is something. That is the problem. He has cheated like anything, not only for her, he has cheated 4 members. This record, he has cheated 4 members.
No, we are not the court of magistrate deciding what punishment should be given at this thing, right? It's not a sessions court. No, you can understand, right? She is not prepared even to give up 5,000 rupees. See, yes. Not even 5,000. There's the question of price. Argue. Right?
Right, when I was like, right. When my life is there, my children are careful. Even I know, I'm not in a position to give education to them.
Yes. So, madam. There's no possibility of a compromise. You get ready and argue. We can ask him to pay a further sum of 1 lakh or something like that. Convince your client to pay more. I mean, obviously, you have a daughter and a son, right? We'll look after them. Nothing happens in 25 lakhs in life. Hey, just a minute. No, so therefore, you should realize that she has no problem contesting the litigation. See, she is a lawyer. So who will be at loss? You will lose more money. A lot of money, and you will lose money because she is a lawyer. She doesn't have any work and she will keep on filing litigation against you. And he's saying yes also. So it's a And whatever matter you argue, I mean, there's no possibility of any compromise, right? Huh? Huh? It's better to compromise, right? Now, what happens supposing if he is not a position to pay the amount and we fix some amount, how it at the most what can be done? This appeal will be dismissed. What's the point? I mean, like, if he is able to pay you, say, further sum of 4 lakhs or something like that, it's better to have it instead of executing it. And I don't know, or we don't know for how long you will be in litigation, right? When matter, yes. Day after, learned counsel for the parties jointly pray for adjournment to enable them to ascertain the possibility of an amicable settlement of the dispute between them. 18th January 23. You said day after tomorrow. Day after tomorrow is 18th. Why? You said day after tomorrow, right? Huh? So we have fixed it day after. Respondent. We'll continue to grow. We will proceed. All right.